So, yesterday we had a Justice Thursday conversation.
We did.
And in our Justice Thursday conversation yesterday, it was all about the recent conversation regarding judiciary and whether it's the conduct of the judiciary as a whole or conduct of individual officers working in the judiciary. But there's this whole political conversation right now in the country. Oh, judiciary, oh, corruption, oh, rampant, oh, no, oh, independence, oh, interdependence, oh, this, oh, the other. One of the people who's been very, very vocal about this is Senior Counsel Ahmednasir, who once sat in the Judicial Service Commission, who once was chair of the Law Society of Kenya. In fact, recently he'd been invited by judges to go and talk to them. And he told them, by the way, guys, you've invited me. This is what I'm coming to tell you. And what he was going to tell them was...
Not what they invited you for.
Hey. So they were like, please, you don't come.
Don't come.
Just don't come. Now, he's also been talking very many things in public regarding several courts, one of them being the Supreme Court of Kenya. And the judges in the Supreme Court sat, and all of them decided to have a conversation with him. They sent him some communique yesterday. The long and short of it, which is saying, because you have said that we are incompetent, we are corrupt, you all those things, you keep talking badly about us, so, and yet you've been appearing before us, so let's sort this thing out once and for all, okay?
Don't come.
Just don't come appear before us, okay? And not just you. You cannot even come here by proxy. That is somebody who represents you, whom we know that you're controlling from outside. No, do not come here in any shape or form before us. Now that has raised some serious issues. Everybody asking, hey, what does that mean? What does this and the other mean? As always, when you have such matters where we seek to understand what the law says, what the Constitution says, we have our friend Waikwa Wanyoike, who is a constitutional lawyer, whom we always invite, and we've invited him for this conversation again. He's in the UK. Waikwa, good morning.
Good morning, Eric.
Thank you very much for joining us this morning. Welcome to the Situation Room. Wherever you are, let's make that the hot seat of the Situation Room.
Thank you, and thank you for inviting me.
Now, we are going to, first of all, give you the day's proverb, just so that everybody is on the same page. CT has the days. This week, the proverbs are from Nigeria. CT has been learning Pidgin, and his teacher, Ndu, has been doing a very good job. So, the Pidgin that CT spoke on Monday is definitely not as the Pidgin he speaks today. He is a very much improved student. He's exceeding expectation, as Ndu would say. So, City, in perfect Pidgin, what is the day's proverb?
Right, in imperfect Pidgin, here goes. No matter how tall okra grow, ain't no go tall pass owner. What?
No matter how tall okra grow.
No, no matter.
No
It's not,
matter.
yes.
No go grow.
Do you know that totally changes the meaning in
no
Pidgin?
matter and no matter are
If you
different.
say na, na, and no, it's very different in
Na
Pidgin.
is now.
Na is. No is no.
Allah. You get it now?
It's a matter of how tall the okra grows. So are we saying no matter, or it is the matter of how it grows, as opposed to it doesn't matter how it grows? So which one is it, City?
How am I supposed to
No
help
matter.
you? How am I supposed to
I
help
don't
you?
know
exactly?
now. It's you to tell me what. Does it say na or no?
What comes after the N? Is it an A or an O?
You who wrote it? What did you?
I wrote an A.
You wrote an A.
Okay.
I think it's an O for the purposes of
See,
this.
this is why I prefaced my statement and said, let me read in imperfect Pidgin. I have been consistent. It's imperfect. Now, please correct it and make it perfect.
No matter how tall okra they grow, it no go grow tall passing owner. Abi?
Yes.
Abi.
Abi? Okay.
Yes.
Waikwa.
Hazard a guess. What do you think this is saying in English?
I don't know. I'm actually a bit forewarned because of do's, so I'm a bit cautious. But it just means that all the way I interpret it is all the equivalent for me is when we say, for example, regardless of how wise a child becomes, they can never have the same wisdom as the parent. So all of us have limits in terms of what knowledge, what competence, what wisdom we may have. That's how I read it.
You cannot surpass.
We have to be humble enough to accept that.
Okay, actually, the message is now the okra should be humble. and know that you will not grow taller than your owner.
Because we'll cut you down and make you into okra soup.
Yes. All right. So, Waikwa, let's get straight into this. You saw, of course, the communication from the Supreme Court yesterday to Ahmednasir Abdullahi, and it elicited some serious conversations online and in various forums. What is your take? First of all, what's your understanding of what the Supreme Court has told Ahmednasir?
My understanding is that the Supreme Court has said to him that because of the manner in which he's conducted himself, and the Supreme Court has been specific in the media, including social media, because he's continued to attack the Supreme Court in this media, according to the Supreme Court, especially in regard to referring to the court in its corporate composition, and there is an indication also referring to judges in their individual capacity as mostly incompetent and corrupt, and I'm using the language in the communication. And because there has been incidents in the past when the court has says it has engaged him on these issues, and he seems not to have changed his posture, then it's barring him, or it's refusing him audience to the Supreme Court, and it seems like for life. But it also indicates that it's not only barring him audience, it's barring him audience through, and through here is important, other lawyers from his firm, or anybody else, any other lawyer appearing on his behalf or holding brief for him. So that's my understanding, which means that he cannot speak at the Supreme Court, or he cannot get audience himself, or he cannot get audience through lawyers in his law firm, or any other lawyer who he asks to hold brief for him. And the nuance there, I think it's important, especially because of what I've seen. There are some of the analysis I've seen in the social media and elsewhere.
So what does that mean? When it says that we are barring you or your law firm, first of all, is it unfair to the law firm?
That's the critical point. So if you look at some of the analysis, there are people who seem to be suggesting that what the court has done is to bar even the law firm. I'm not sure the law firm from appearing, or lawyers from the law firm appearing before the Supreme Court. I don't necessarily agree with that interpretation myself. What I think the court is specifically saying is that if, for example, there is a matter where he is counsel of record, or the counsel who is retained, and there are different ways that lawyers are able to appear before the court. Sometimes they'll appear because they are the primary lawyers who are hired by a client. Sometimes they will appear because they're working with another lawyer who's hired by the client, but they are assisting that lawyer. And in our designation, for example, where you have senior counsel, it's not uncommon that a junior lawyer who is not even with the law firm, or could be with the law firm, is the one who has the day-to-day carriage or responsibility over the matter, but the senior lawyer, because of the experience, is called upon, for example, to come and do specific duties. So, for example, addressing the court and to lead the junior lawyer. So what some people seem to be saying is that no lawyer from his law firm can appear before the Supreme Court. That's not how I read the communication from the Supreme Court. I read it to mean that if it's Ahmednasir Abdullahi, who is the one who is supposed to be representing the client, or appearing for the client, or appearing in the matter himself as a lawyer, but for some reason designates a lawyer from his law firm to appear on his own behalf, which is through him, through that lawyer, for example, or a lawyer who is not from his law firm, which is a common practice also for lawyers to ask other lawyers to hold brief in court, then the court will not hear, because in effect, the court would be hearing him, because that's the normal understanding of when a lawyer is appearing on behalf, or appearing or holding brief for another lawyer.
Okay.
So, Waikwa, what? I mean, all of this stemmed from the communication that we saw coming from the Supreme Court. All of this stemmed from their, disappreciation of would-be comments and things that he had been saying over time. According to the law, or what is constituted, can the Supreme Court make such a decision based on what would be termed as public ridicule or criticism? Can they make a decision as such, like what they did yesterday, as a court, because of criticism or ridicule of the court itself?
I think it's important to nuance a few things. The Constitution actually expects the public to criticize, comment, and assess how public institutions perform. And Supreme Court is not immune to that. Every public institution is immune to that, is subject to that. Public officers are subject to that, and judges are public officers. So it's important to start with that foundational fact that the Constitution itself actually encourages people to give commentary to how public officers and public offices are performing. That's one. The second is that that is a component of freedom of expression that the Constitution guarantees, the freedom to criticize and all that. And the limitations on the freedom of expression are quite actually limited. So sometimes, and when it comes to especially freedom of expression that's directed to public officers, the law is much more permissive about what members of the public can say, because there is an acceptance in law that a public officer, or the kind of criticism a public officer should be able to receive, is not your average criticism, that you criticize your neighbor or something, because they have that public duty, and so they should be much more open, and the law is going to permit or will be a bit more elastic in terms of the levels of criticism. That relates to the criticism that, because you specifically used the word public, from the public. But remember, and this is the second fundamental foundational fact, remember, lawyers are what we call officers of the court. And so when lawyers are commenting on matters that relate to court, relate to judges, they are as much as the Constitution applies to them, they have a heightened duty being public officers, and there are specifically rules that apply to how they are supposed to communicate about their own opinion or their client's opinion about the court or about individual judges. And those are what we call code of conduct for lawyers. And this is universal. Any jurisdiction you go, you'll find that lawyers have code of conduct. Sometimes those code of conduct are actually statutes of parliament. Sometimes they are regulations, and sometimes they are what we call professional rules. So it's important to know that when we are assessing who has made the criticism, the starting point is to ask, who is this person? And especially, are they a lawyer? And are they bound by more rules than your average citizen? To your question, to the other part of your question, whether it's within or possible for the court to do this. It is possible for the court to discipline, if you want to use that word, or to provide caution to a lawyer. Again, there are different ways lawyers are regulated. The primary way is through the Law Society. The Law Society, through itself or through its disciplinary tribunal, has regulatory role of lawyers. And so if, for example, there is an opinion, whether based on a complaint by a member of the public, another lawyer, or through its own motion that a lawyer has misconducted himself, then the Law Society has the mandate to regulate. But the court, which is the second way that a lawyer is regulated, can also regulate the conduct of a lawyer. Ordinarily, that happens when the lawyer is before the court or has active proceeding before the court, and often happens to be restricted to the conduct of the matters or the matter that is before the court. That does not mean entirely that the court cannot go beyond an active matter, but it's unusual for the court to have this blanket regulation over the lawyer, and so it's important to say that again, there are nuances to this. It's not impossible for the court to regulate a lawyer. Whether this was right or wrong, I think that's what we should debate, or whether the court was right or wrong to do what it did is what we should debate.
I mean, so can we ask that question then, Waikwa? Because I think it is important to look at. A lot of times we're applying, through this, obviously, applying the law, looking at what is constituted, but then the way in which it looks to the public also, I think, is just as important. And the optics that play out here, that he's brought up issues severally. And one would say, well, rather than discuss those issues, or rather than look into the fundamentals of those issues, the choice that was taken was to basically gag him. And is that what should be? And that's where we start to look at, was it right or wrong? Should they have said, here's a warning? You know, should they have said, this is what we're asking you to do, before they brought this what looks like blanket, complete banning kind of thing? And then one would ask the question, is there any merit in then the things that he's been saying?
Those are quite a few and very loaded questions. So let's start with whether the court can do this, and then go to whether how it did it is acceptable, and then the issue of merit. So your earlier question was about whether the court has power, and that's where you start. Does the court have power to do what it did? And we can debate that, and lawyers are debating that. The public is debating that. There are provisions of the law that does give credence to the ability of the court to regulate the conduct of lawyers. We can debate in what circumstances that could be done, and then we can debate whether it can be done in the way the court did. But then the second question, even assuming that the court has powers to do this, the second question is what process or procedure should the court follow in doing so, and did the court follow the right procedure? And I think actually more than whether the court can reprimand or take action against Ahmednasir, the more contentious question will be whether how it did it was right or is supported by the law. Just very briefly to the first question on power. Again, it's important for your listeners to know that the reason lawyers are called officers of the court is because they have a foundational duty to protect the reputation of the administration of justice. And so that is a higher duty than your regular individual on the street. And the idea there is that if there is disrepute in the administration of justice, then the whole foundation for the authority of the court crumbles or is questioned. And so lawyers, especially as part of the legal profession, have an overarching duty to protect that reputation. And I think that's partly what the court is saying it's in its communication. When it comes to process, remember, court processes are processes that are very structured, and we call them the part of the reason we say a court is a court of record. So everything that is done in court has to be structured. If you want to have a dispute resolved in court, you don't just show up in court and say, I want my case heard. There is procedure. If a judge wants something done, there is a procedure that a judge would follow. And the questions that arise is, for example, was it right for the court to, and I may not have all the facts, but was it right for the court to communicate or to, first of all, sit and take a decision in the manner it did? Was there a live case before it under which it could have initiated these proceedings? Or is there another basis under which it could have initiated the proceedings? The court in the communication talks about an old case that was decided actually when Chief Justice Maraga was still in court. Is that the basis under which this action is taken? Or is it on the basis of recent utterances by the senior counsel? The court, and I haven't seen this, also indicates there is evidence and says that it's attached records of evidence. How did it obtain that evidence? And more fundamentally, what is this that the court has issued? Is it a decision or a communication? And if it's a decision, is it the kind that the Constitution contemplates the court can issue? So, under, for example, Article 163(7), which is the authority where the Supreme Court derives to be able to issue decision. Can this decision be revisited either by the court itself, or can it be judicially reviewed in a lower court, that is the High Court? So the process questions for me are, I think, are more stickier than even the power question.
Let's take a break. We continue the conversation shortly at 23 to 9. Waikwa Wanyoike is a constitutional lawyer. He's joining us this morning. We're looking at, all right, so what's actually the legal position of what we've seen? The communication from the Supreme Court of Kenya to Senior Counsel Ahmednasir Abdullahi, basically barring him from appearing before the court or through directly or through any form of representation. What does it mean and what precedent is it setting? Just back to the initial question, did you say yes or no to the question whether the Supreme Court has any legal basis to bar a lawyer from appearing before it?
Yes, the court can actually bar a lawyer from appearing before it. And in fact, in the Supreme Court Act, the court does have power to require a lawyer not, for example, to appear before it or to discipline a lawyer in proceeding for whatever you may consider to be unacceptable behavior. There is questions about, and the provisions of the law, the specific provision that I'm referring to, seem to cap that to not more than 18 months. So there's questions about whether, if that is the provision, for example, the court is relying on, which is unclear because the reasons or the communication does not indicate that, whether the court again has the powers beyond the power to bar, but how far does that power extend?
Okay. Then the second bit...
and Eric, I think it's important to know that courts have powers generally to regulate their own proceedings. And again, and in doing that, and that's why, for example, courts are given powers of contempt, and the power of contempt can be on the face. So when the contempt is happening before a judge, or it could be contempt that happens when the judge is not looking. So it happening maybe outside or where the judge is not available, but is, for example, connected to the proceeding. So courts have these powers because they are the powers that allow them to regulate their proceedings. Again, the question that remains is, was this power being exercised in the context of a continuing proceeding, which is not indicated, or was it being exercised generally? And if you look at the letter, for example, the communication, you'll notice that it's copied to, for example, other law firms. Why is it copied to other law firms? That's unclear to me, and maybe unclear to other members of the bar or the public.
You also spoke about the importance of looking at the process of arriving at this decision, where you said it could be you're arriving at a decision because of a live case where the court then feels that this particular advocate has breached the proceedings of the court, sub judice or whatever they've done, or it could be because of a matter that's been brought before the court to the court's attention by another party on what has happened with regards to a certain lawyer. In this particular case, you are wondering what the process has been on the court arriving at the decision.
Yes, again, because it's unclear to, at least to me. So the court does indicate, to be fair to the court, that this does arise from comments or communication is done in the media, including social media. But the court does also allude to continuing and past behavior. But in law, when a court issues a decision, that decision, as I stated from the beginning, arises from a process that is happening. And in the context of contempt, for example, in the context of court taking some disciplinary action against counsel or any individual who is a litigant, that could arise from a proceeding that is before the court. And again, it's unclear to me. But can I say two other things that I think are also important to highlight? And that goes to the question about, also touches to the question about whether the court has power to bar. There is the question about, even assuming the court had the power, even assuming that the process that the court has followed is the right process, is this a proportionate
punishment?
Is it a proportionate punishment? And is it a punishment? In assessing, first of all, whether it's a proportionate punishment, you actually start with, is it a punishment that is contemplated by the law or that is available in law? And even assuming it was, again, looking at the conduct that is attributed or that is being punished, is it proportionate?
What do you say?
Because there
what do you say? You've already established, you've already said yourself that it's based in some provisions of the law. So whether it's proportionate or not, how would you judge how proportionate it is? What would you use as a measure of gauging the proportionate nature of it?
So just to be clear, I've not specifically say that it's based on the provision of the law. I was answering the general question whether the court has power to punish or to take action, including refusing a lawyer audience. And to that question, to that general question, yes. And actually that power, as I indicated, could be derived from different places, including, for example, a specific provision of the Supreme Court. But again, it's unclear from the communication whether that is any of that power is what the court was exercising. And that's why reasons are always important, because sometimes reasons will set the foundational basis where the court is coming from. And so there are questions about that. On how to establish proportionate. Proportionality is based on, first of all, does the law, first of all, allow for this kind of punishment, and to the extent, for example, that the punishment is defined. Remember, rule of law requires that any action by a public officer has to find a basis in law. So the first question then that is asked is there a general power for the court to be able to disbar a member from appearing before it for life? But assuming that there is that power, and so the court ought to indicate whether there is that specific power to bar people for life. As I indicated, the provision in the Supreme Court does cap that kind of punishment to 18 months. But assuming if the court has that power, is it proportional? And proportionality is based on now the intensity of the reprehensible behavior,
the severity.
And again, you need to be able to see the evidence to be able to determine.
Who would determine, Waikwa? Because here we are talking about the apex court, right? Who's made this determination, and then has come about to a decision whereby they've brought out an individual who they said has done X, Y, Z. They have then gone ahead to prefer a punishment on him. Who then would be the one to determine whether this was outside the scope of power? Who then would be the one to come and ask the questions as to whether they exceeded the cap, which you've said is 18 months? But the letter is very clear that they've banned him for life.
Well, they haven't said life.
Well,
they just haven't said till when.
They haven't said till when. All right. Who then would be able to come to ask questions to determine whether this decision exceeded the power of the court? We're talking about the apex court. Who then would do that? Who would ask the questions? Who could he appeal? Who would he appeal to? What?
My own belief is that this is a decision that Ahmednasir or anyone else can take to the High Court, specifically for judicial review, so that the High Court is able to, first of all, determine whether it has powers to hear the case. I think the High Court would have power to hear the case because one thing that is very clear to me, that this is not the kind of decision that is contemplated in Article 163(7), which means that it's a final decision of the court. In fact, I see this more as a decision in administrative action decision, which we call an Article 47 decision, which is amenable to judicial review by the High Court. And then all the questions now you're raising here would come before that court. Of course, that court, the first thing it would have to say or to determine is whether it has jurisdiction. I want to emphasize two things, and this goes to an earlier question that you raised and also raised by Eric. It's important, the question about merit. It's important also for the public to know that what makes it very difficult for judges is because judges have the currency for judges is two things, or primarily two things: intellectual heft and integrity. And the reason why the law is very protective of judges, and especially the law is protective of judges based on the conduct of lawyers, is because if the judges or the court lose integrity, then the whole administration or the reputation of the administration of justice is in disrepute. And so it's important when allegations are made against judges or a court, and especially when those allegations are made by a lawyer, that there is evidence or basis for it. And so those questions to be raised or to be determined. And in fact, if this goes to judicial review, part of what I think the court would be looking at, assuming the court takes jurisdiction, is whether there was a basis, even for Ahmednasir also, to be making this allegation. And has he provided evidence, or does he have evidence to show? But the last point I would also say, and why this becomes very controversial, is the responsibility of the Supreme Court. Judges have immense power. In fact, in the architecture of our Constitution, the final authority on the Constitution is on judges. And so sometimes that's why judges have to be extremely cautious on how they exercise that power. And the uproar, for example, I've seen, especially from the members of the bar, I think arises from the fear that given the authority and the finality that judges exercise their power, was it right, for example, for the Supreme Court to have taken what seems to be a very drastic decision, and especially where it's unclear what process was followed, including whether, for example, there was evidence or there was an opportunity for senior counsel to defend himself or to make representation.
A lot of sorry, CT, go ahead.
What I'm pondering over is where does the Judicial Service Commission come into all this? I mean, the courts are supposed to have the role of refereeing. They are supposed to be arbiters. So when you have a tussle with an arbiter, yes, you said you can go for judicial review, but what exactly does the Judicial Service Commission have any say on a matter such as this one?
So the mandate of the Judicial Service Commission especially, of course, the Judicial Service Commission has various duties, but one of the main duties is to discipline judges. But for Judicial Service Commission to be able to discipline a judge or to inquire into the question whether a judge should be disciplined, there has to be a complaint launched before it, or the Judicial Service Commission has to notice something that the judge has done that requires it to inquire into the conduct of the judge. And this is part of the dilemma here, because if you make accusation in the public, for example, indicate that a court or a judge is corrupt, but you don't present a complaint against that judge or the court, then the Judicial Service Commission can't do anything. But it's also being very, very unfair when, for example, somebody makes unsubstantiated claim about corruption, either of a court or a judge, without offering evidence. Doesn't mean that there is no corruption in the judiciary, but there is also a duty for those who make these kind of claims to be able to provide evidence, and actually, to the extent possible, follow the procedure to be able to get the determination or the proceedings that will lead to the determination.
In that case, then,
Waikwa,
in that case, then, can the Judicial Service Commission, not having noticed the public nature of a complaint, can the Judicial Service Commission not summon the complainant and tell them, come and tell us what you have, and maybe then start moving the wheels of motion towards addressing the complaints being raised in the public? For example, directly, could the Judicial Service Commission not invite Ahmednasir Abdullahi and tell him, come, we notice that you have issues against judges of the court. Tell us what particular issue you have against what specific judges.
You remember, a complaint for purposes of legal proceeding is a very specific thing. Any allegations made, for example, in media or social media, does not amount to a complaint. And in fact, if, for example, the Judicial Service Commission, because this is not necessarily just about Ahmednasir's case, it's also about any, for example, criticism either by a lawyer or a member of public that is made against the court or judges. If the Judicial Service Commission, anytime it notices a criticism against a judge or an accusation against a judge in public media, where there is no evidence attached to that, was to launch it as a complaint, then it would not be able to move. It's different when, if, for example,
and as we conclude,
evidence, there is evidence that is provided that shows that Officer X or Judge X was involved in an impropriety. That's very different.
I've got to stop you there,
accusation, a blanket accusation is not sufficient.
Stop you there. Thank you very much, Waikwa. Waikwa Wanyoike, constitutional lawyer, has been giving us the breakdown of how he sees the matter playing out.
This is the Situation Room, the only way to start your day.